All right. So we will be talking about the Intellectual Property Office. No. So the creation of the Intellectual Property Office to replace the Bureau of Patents, Trademarks, and Technology Transfer is one of the primary objectives of Republic Act number 8293. So therefore, if you look at the Republic Act 8293, it wanted to replace the Bureau of Patents, Trademarks, and Technology Transfer into the Intellectual Property Office. The creation of the new office was brought about by the need. Why is this done? Because they wanted to restructure the existing organization handling registration of patents and trademarks so that the challenges brought about by the growing volume of applications may be addressed. So there are many people who are applying for it. So there's a need for us to address the growing volume of application. It also aims to improve the efficiency of the office through faster processing and applications as well as resolutions of their inter-parties cases. So the proponents of the law, led by Senator Raul Roco, they said that the distribution of the policy formulation, adjudicatory, and administrative functions, which at present are performed solely by the only person who is doing it is the Director of Patents to the two different officials. Second, there is a need to provide the Intellectual Property Office with its own administrative and financial services in order to streamline. Now, we need to streamline its administrative affairs. And third, ensuring that decisions on intellectual property rights are consistent and correct by centralizing the adjudicatory functions in these cases in the Intellectual Property Office. So, curiously, however, this topic about Intellectual Property Office is not included in the Supreme Court Bar Exam syllabus. Nevertheless, there are important concepts in this chapter that students need to be familiar, and specifically the organization and the jurisdiction of the Intellectual Property Office, including the administrative penalties that the office may impose upon its infringer. So let's talk about the creation of the Intellectual Property Office. The Intellectual Property Office was created under RA 8293. This office again replaced the Bureau of Patents, Trademarks, and Technology Transfer. Now, how about its organization? It is headed by a Director General. So, Director General ang head, who is assisted by two deputies Director General. And the office is divided into 7 bureaus, each of which is headed by a director and assisted by an assistant director. These bureaus are the Bureau of Patents, the Bureau of Trademarks, Bureau of Legal Affairs, Documentation, Information, and Technology Transfer Bureau, the Management Information System and EDP Bureau, the Administrative, Financial, and Personnel Services Bureau, and the Bureau of Copyright and Other Related Rights. So the Director General, deputies, Director General, directors, and assistant directors of the office are all appointed by the President. So the other officers and employees of the office shall be appointed by the Secretary of the Department of Trade and Industry conformably with and under the Civil Service Law. So the following are declared functions of the office. So they should examine applications for grant of letters patent for inventions and register utility models and industrial design. Examine applications for the registration of marks and geographic indication integrated circuits. And they have to register technology transfer agreements and settle disputes involving technology transfer payments covered by the provisions of Part 2, Chapter 9 on voluntary licensing, and develop and implement strategies to promote and facilitate technology transfer. They also need to promote the use of patent information as a tool for technology development. They also have to publish regularly in its own publication the patents, marks, utility models, and industrial designs issued and approved, and the technology transfer arrangements registered. So they also have to administratively adjudicate contested proceedings affecting intellectual property rights and coordinate with other government agencies and the private sector efforts to formulate and implement plans and policies to strengthen the protection of intellectual property rights in the country. So let's talk about the Director General. What are his functions? The Director General of the Intellectual Property Office, as the head of the office, manages and directs all functions and activities of the office. This includes the promulgation of rules and regulations to implement the objectives, policies, plans, and programs and projects of the office. This managing function is limited by the proviso that the Director General shall be subject to the supervision of the Secretary of the Department of Trade and Industry when the exercise of the authority is to propose policies and standards in relation to the following. So first is the effective and efficient and economical operations of the office requiring statutory enactment. So coordination with other agencies of government in relation to the enforcement of the intellectual property rights, the recognition of attorneys, agents, or other persons representing the applicants of other parties before the office. And they also have the establishment of fees for the filing and processing of the application for a patent. The utility model or industrial design or mark of the collective mark, geographic indication, and other marks of ownership, and for all other services performed and materials furnished by the office. So, if you wanted to become a Director General, now what are your qualifications? The Director General and the deputies and the Director General must be natural born citizens of the Philippines, at least 35 years of age on the day of their appointment, and holders of college degree and of proven competence, integrity, probity, and independence, provided that the Director General and at least one Deputy Director General shall be members of the Philippine Bar who have engaged in the practice of law for at least 10 years. So, dapat 10 years sila nag-practice with law. Now, provided further that in the selection of the Director General and the Deputies Director General, consideration shall be given to such qualifications as would result as far as practicable in the imbalance or the balanced representation of the Directorate General of the various fields of intellectual property. So what is their term? No, the Director General and the Deputies Director General shall be appointed by the President for a term of 5 years and shall be eligible for reappointment only once. So only 10 years, no minimum. Appointment to any vacancy shall only for the unexpired term of the predecessor. It was also provided that in the law, that the first Director General appointed under the law shall have a first term of 7 years. So, first one who will be given the responsibility will have to serve for 7 years. Section 7, Paragraph B of the Republic Act 8293 as amended by Republic Act number 10372 provides exercise and exclusive appellate jurisdiction over all decisions rendered by the Director of Legal Affairs, the Director of Patents, the Director of Trademarks, the Director of Copyright and other related rights, and the Director of the Documentation, Information, and Technology Transfer Bureau, the decisions of the Director General in the exercise of his appellate jurisdiction in respect of the decisions of the Director of Patents, the Director of Trademarks, and Director of the Copyright and other related rights shall be appealable to the Court of Appeals in accordance with the rules of court, and those in respect with the decisions of the Director of the Documentation, Information, and Technology Transfer Bureau shall be appealable to the Secretary of Trade and Industry. So, the other one is appealable to the Court of Appeals, and with court, those under the Technology Transfer Bureau shall be appealable to the Secretary of Trade and Industry, the DTI. No? Thus, the Director General, by express provision of law, as amended, retains his exclusive appellate jurisdiction over all decisions rendered by the Director of Legal Affairs and the Director of Patents and Director of Trademarks, Director of Documentation, Information, and Technology Transfer Bureau, and now the Director of Copyright and other related rights. With the creation of the Bureau of Copyright and other related rights, the mandatory law divested the Director General with original jurisdiction to resolve disputes relating to terms of license involving author's right to public performance. So here we see that the Bureau of Copyright and other related rights, with the mandatory law provided, it divested the Director General with original jurisdiction to resolve disputes relating to the terms of license involving author's right to public performance. So jurisdiction over interlocutory orders of the Bureau of Legal Affairs. No? So mga before the judgment orders, no, there is a need to qualify the jurisdiction of the Director General insofar as the decisions of the Bureau of Legal Affairs is concerned. The Supreme Court explained that only decisions of the Bureau of Legal Affairs are appealable to the Director General. The Court of Appeals may exercise jurisdiction over interlocutory orders of the Bureau of Legal Affairs. So, to illustrate that, we have the case now. It's called just the final order, and the title is Philippine Pharma Health Incorporated versus Pfizer and Pfizer Philippine Incorporated. So, what is the case about? Let's talk about the facts. Now, the case arose from the complaint for patent infringement filed by the respondent Pfizer against petitioner Philippine Pharma Wealth with the Bureau of Legal Affairs. The BLA issued an order issuing a preliminary injunction against the petitioner who was effective for 90 days upon receipt. Prior to the expiration of the injunction order, respondent filed a motion of extension of writ of preliminary injunction. So the motion was denied by the Bureau of Legal Affairs. Now, the motion for reconsideration filed by by the respondent was also denied by the Bureau of Legal Affairs. The respondent then filed a special civil action for certiorari with the Court of Appeals assailing the resolution of the Bureau of Legal Affairs. So while this case was pending, the respondent filed a complaint with the Regional Trial Court of Makati City for infringement and unfair competition. The petitioner filed a motion to dismiss based on the ground of forum shopping. So there has been multiple cases filed. Now, on January 18, 2005, the CA issued its question resolution approving the bond posted by the respondents pursuant to the resolution issued by the Appellate Court on March 23, 2004, which directed the issuance of a temporary restraining order conditioned upon the filing of a bond. On even date, the CA issued a temporary restraining order which prohibited petitioner from importing, distributing, and selling or ordering for sale the sulbactam ampicillin products to any hospital or to any other entity in the Philippines, or from infringing Pfizer's Incorporated Philippine Patent Number 21116, not to Loca 1, and impounding all the sales invoices and other documents evidencing sales by the petitioner of sulbactam ampicillin products. Among others, the petitioner questioned the exercise of jurisdiction of the CA over the case. The petitioner argued that pursuant to the doctrine of primary jurisdiction, the Director General of the IPO Intellectual Property Office, not the CA, has jurisdiction to review the question orders of the Director of the Bureau of Legal Affairs Intellectual Property Office. Whether the Court of Appeals erred in exercising jurisdiction, because here in this case the CA really exercises jurisdiction over the case. The ruling here is no. What is in question is an interlocutory order, and not a final decision of the BLA. So it is true that under Section 7 of RA 8293, otherwise known as the Intellectual Property Code of the Philippines, which is presently the prevailing law, the Director General of the IPO exercises exclusive appellate jurisdiction over all decisions rendered by the Director of Bureau of Legal Affairs. However, what is being questioned before the CA is not a decision. It is an interlocutory order by the Bureau of Legal Affairs, denying respondents' motion to extend the life of the preliminary injunction issued in their favor. The RA 8293 is silent about this matter. Hence, the rules of the court shall apply in a suppletory order or manner. So RA 8293 is silent with respect to any remedy available to the litigants who intend to question an interlocutory order issued by the Bureau of Legal Affairs. However, Section 1, Rule 14 of the Rules and Regulations of Administrative Complaints for violation of laws involving individual property rights simply provides the interlocutory order shall not be appealable. The said rules and regulations do not prescribe a procedure within the administrative machinery to be followed in assailing orders issued by the BLA IPO pending final resolution of the case filed with them. Hence, in the absence of such remedy, the provisions of the rules of court shall apply in a suppletory manner as provided under Section 3, Rule 1 of the same rules and regulations. Hence, in the present case, respondent correctly resorted to the filing of the special civil action for certiorari with CA to question the assailed orders of BLA or Bureau of Legal Affairs, IPO, as they cannot appeal therefrom and they have no other plain, speedy, and adequate remedy in the order of or ordinary course of law. This is consistent with Rule 65 of the Rules of Court as amended. So there was also no violation of the doctrine of primary jurisdiction. Based on the foregoing, the court finds that the respondents' initial filing of their complaint was with the Bureau of Legal Affairs instead of the regular courts is in keeping with the doctrine of primary jurisdiction, owing to the fact that the determination of the basic issue whether the petitioner violated respondents' patent rights requires the exercise of the Intellectual Property Office of sound administrative discretion, which is based on the agency's special competence, knowledge, and experience. However, the propriety of extending the life of the writ of preliminary injunction issued by the BLA IPO and the exercise of its quasi-judicial power is no longer a matter that falls within the jurisdiction of the said administrative agency, particularly that is of its Director General. The resolution of this issue, which was raised before the CA, does not demand the exercise by the IPO of a sound administrative discretion requiring special knowledge, experience or services in determining technical and intricate matters of fact. It is settled that one of the exceptions to the doctrine of primary jurisdiction is where question involved is purely legal. No, just like in this case, it's purely legal, and will ultimately have to be decided by the courts of justice. This is the case with respect to the issue raised in the petition filed with the CA. And number 4, the implementing rules and regulations of A293 do not provide for procedural remedy to question interlocutory orders issued by the Bureau of Legal Affairs. Moreover, as discussed earlier, RA 293 and its implementing rules and regulations does not provide for procedural remedy to question interlocutory orders issued by the BLA IPO. In this regard, it bears to reiterate that the judicial power of the courts are provided for under the Constitution includes the authority of the courts to determine in an appropriate action the validity of the acts of the political departments. So the judicial power also includes the duty of the courts and the justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the branch or instrumentality of the government. Hence, CA, not the IPO Director General, has the jurisdiction to determine whether the BLA IPO committed grave abuse of discretion in denying respondents' motion to extend the effectivity of the writ of preliminary injunction which the said office earlier issued. So, where to appeal the decision of the Director General? In case of an adverse decision of the Director General, appeal may be made to the Court of Appeals or the Secretary of the Department of Trade and Industry, as the case may be. The rule is that the decisions of the Director General in the exercise of his appellate jurisdiction in respect to the decisions of the Director of Patents, the Director of Trademarks, and the Director of Copyright and other related rights are appealable to the Court of Appeals in accordance with the rules of court. So as we can see here, the rule is that the decisions of the Director General in the exercise of his appellate jurisdiction in respect to the decisions of the Director of Patents, etc., trademarks, copyright, and other are appealable to the CA. Okay, the decisions of the Director General in respect to the decisions of Director of Documentation, Information Technology Transfer Bureau, on the other hand, are appealable to the Secretary of Trade and Industry. So this is related to the documentation, then Information and Technology Transfer Bureau, then DTI has the jurisdiction. So the bureaus here, the Intellectual Property Office is divided into 6 bureaus headed by the director and assisted by the assistant director. The bureau has the following functions. First is the search and examination of patent application and the grant of patents. Then number 2, registration of utility models, industrial designs, and integrated circuits, and conduct of studies and researches in the field of patents in order to assist the Director General in formulating policies on the administration and examination of patents. So here, the Bureau of Trademarks, the Bureau has the following functions. You have to search and examination of applications for the registration of marks, geographic indications, and other marks of ownership, and the issuance of certificates of registration. You can also conduct studies and researches in the field of trademarks in order to assist the Director General in formulating policies on the administration and examination of trademarks. So here, the Bureau of Copyright and other related rights, the Bureau has the following functions. You can exercise original jurisdiction to resolve disputes relating to the terms of license involving the author's right to public performance or other communication of his work, and accept, review, and decide on applications for the accreditation and collective management of organizations for similar entities. You can also conduct studies and researches in the field of copyright and related rights, and provide other copyright and related rights to service and charge reasonable fees therefore. So the Bureau of Legal Affairs, the Bureau has the following functions here: and decide opposition to the application for registration marks, cancellation of trademarks, subject to the provisions of Section 64 Republic Act 8293, cancellation of patents, utility models, and industrial designs, and petitions for compulsory licensing of patents. It also exercises original jurisdiction on administrative complaints for violation of laws involving intellectual property rights, provided that its jurisdiction is limited to complaints where the total damages claimed are not less than 200,000 pesos, provided further that the availment of the provisional remedies may be granted in accordance with the rules of court. The Director of Legal Affairs shall have the power to hold and punish for contempt all those who disregard orders of writs issued in the course of the proceedings. The administrative penalties that may be imposed by the Director of Legal Affairs are the following: the issuance of a cease and desist order, which shall specify the acts that the respondent shall cease and desist from and shall require him to submit a compliance report within a reasonable time, which shall be fixed in the order. Okay, and then the acceptance of a voluntary assurance of compliance of discontinuance as may be imposed. Such voluntary assurance may include one or more of the following. It can include an assurance to comply with the provisions of the intellectual property law violated, an assurance to refrain from engaging in unlawful and unfair acts and practices subject of the formal investigation, an assurance to recall, replace, repair, or refund the money value of defective goods distributed in commerce, an assurance to reimburse the complaint the expenses, the costs incurred in prosecuting the case in the Bureau of Legal Affairs. So the Director of Legal Affairs may also require the respondent to submit periodic compliance reports and file a bond to guarantee compliance of its undertaking. The condemnation of seizure of products which are subject to the offense, the goods seized hereunder shall be disposed of in such manner as may be deemed appropriate by the Director of Legal Affairs, such as by sale, donation to distressed local governments, or to charitable or relief institution, exportation, recycling into other goods, or any combination thereof, under such guidelines as he may provide. The forfeiture of paraphernalia and all real and personal properties which have been used in the commission of the offense, and the imposition of administrative fines in such amount as deemed reasonable by the Director of Legal Affairs, which shall in no case be less than 5,000 pesos, no more than 150,000 pesos. In addition, an additional fine of not more than 1,000 pesos shall be imposed for each day of continuing violation. So the cancellation of any permit, license, authority, or registration which may have been granted by the office, or the suspension of the validity thereof for such period of time as the Director of Legal Affairs may seem reasonable, which will not exceed 1 year. The withholding of any permit, license, authority, or registration which is being secured by the respondent from the office. Also, there should be an assessment of damages, censure, and other analogous penalties and sanctions. So we will talk about another case. Here we have In and Out Burger Incorporated, Siwani Incorporated, or Benitas Frights Incorporated, GR number 179127, December 24, 2008. So what are the facts of this case? The Court of Appeals, in its assail decision, decreed that the IPO, Director of Legal Affairs, and the IPO Director General do not have jurisdiction over cases involving unfair competition. So here, the Director General said they do not have jurisdiction over cases involving unfair competition. Among others, the Court of Appeals declared that the Section 163 of the Intellectual Property Code specifically confers upon the regular courts and not the Bureau of Legal Affairs. Not the Bureau of Legal Affairs has jurisdiction on that. Sole jurisdiction to hear and decide cases involving provisions of Intellectual Property Code, particularly trademarks. Consequently, the IPO Director General has no jurisdiction to rule on supposed violations of these provisions of the Intellectual Property Code. So what is the issue here? Whether the Intellectual Property Office has jurisdiction over administrative complaints of intellectual property rights violations. So what is the ruling? Yes, no? The answer is yes. Intellectual property has jurisdiction over administrative complaints for intellectual property rights violations. One, what is the reason? Complaints seeking the cancellation of disputed mark and damages for violation of petitioner's intellectual property right falls within the jurisdiction of the IPO Director of Legal Affairs. In the aforestated decision, the Court of Appeals adjudged that the IPO Director of Legal Affairs and the IPO Director General had no jurisdiction over the administrative proceedings below to rule on issue of unfair competition because Section 163 of the Intellectual Property Code confers jurisdiction over particular provisions in the law on trademarks on regular courts exclusively. According to the said provision, if you look at Section 163, jurisdiction of court, all actions under Sections 150, 155, 164, 166 to 169 shall be brought before the proper courts with appropriate jurisdiction under existing laws. Okay, so The provisions referred to Section 163 are Section 150 on license contracts. So if you look at Section 155 on remedies on infringement, Section 164 on notice of filing suit given to the director, and Section 166 on goods bearing infringing marks or trade names, Section 167 on collective marks, and Section 168 on unfair competition rights regulation remedies, and Section 169 on false designation of origin, false description of representation. So the court here disagrees with the Court of Appeals. No, the Supreme Court actually disagrees with what the Court of Appeals decreed in the first part. Section 10 of the Intellectual Property Code specifically identifies the functions of the Bureau of Legal Affairs. Thus, Section 10, the Bureau of Legal Affairs shall have the following functions. They have the function to hear and decide opposition to the application for registration of marks, cancellation of trademarks, subject to the provision of Section 64. And then we have cancellation of patents and utility models and industrial designs, and petitions for compulsory licensing of patents. So we have here an exercise of original jurisdiction in administrative complaints for violations of laws involving intellectual property rights, provided that its jurisdiction is limited to complaints where the total damages claimed are not less than 200,000 pesos, provided further that the availment of the provisional remedies may be granted in accordance with the rules of court. So the director of the legal affairs shall have power to hold and punish for contempt all those who disregard orders of writs issued in the course of proceedings. So unquestionably, the petitioner's complaint, which seeks the cancellation of the disputed mark in the name of the respondent Sikwahi Incorporated and damages for the violation of petitioner's intellectual property rights, falls within the jurisdiction of the IPO Director of Legal Affairs. The law recognizes the appellate jurisdiction of the IPO Director General. The Intellectual Property Code also expressly recognizes the appellate jurisdiction of the IPO Director General over the decisions of the IPO Director of Legal Affairs. To wit, we have Section 7, the Director General and Deputies Director General functions. The Director General shall exercise the following powers and functions. First, exercise exclusive appellate jurisdiction over all decisions rendered by the Director of Legal Affairs and the Director of Patents and the Director of Trademarks and the Director of Documentation, Information and Technology Transfer Bureau. The decisions of the Director General in the exercise of its appellate jurisdiction in respect to the decisions of the Director of Patents and the Director of Trademarks shall be appealable to the Court of Appeals in accordance with the rules of court, and those in respect with the decision of the Director of Documentation, Information Technology Transfer Bureau shall be appealable to the Secretary of Trade and Industry. So the law recognizes the current jurisdiction of civil courts and the IPO over unfair competition cases. The Court of Appeals erroneously reasoned that Section 10 of the Intellectual Property Code, conferring upon the BLA IPO jurisdiction over administrative complaints for violations of intellectual property rights. It's a general provision over which the specific provision on Section 160 of the same code found under Part 3 thereof, particularly governing trademark services and trade names, must prevail. Proceeding therefrom, the Court of Appeals incorrectly concluded that all actions involving trademarks, including changes of unfair competition, are under the exclusive jurisdiction of the civil courts. Such interpretation is not supported by the provisions of the Intellectual Property Code. While Section 163 thereof vests in civil courts jurisdiction over cases of unfair competition, nothing in the said section states that regular courts have sole jurisdiction over unfair competition cases to the exclusion of administrative bodies. On the contrary, Sections 160 and 170, which are found under Part 3 of the Intellectual Property Code, recognize the concurrent. So, ang jurisdiction here is concurrent, not exclusive and sole jurisdiction. These two provisions read: Section 160, right to the foreign corporation to sue in trademark or service mark enforcement action. Any foreign national or juridical person who meets the requirements of Section 3 of this Act does not engage in the business of the Philippines may bring a civil or administrative action hereunder for opposition, cancellation, infringement of unfair competition, or false designation of origin and false description, whether or not it is licensed to do business in the Philippines under existing laws. So we look at also the penalties provided, no, independent of civil and administrative sanctions imposed by law. A criminal penalty of imprisonment from 2 years to 5 years and a fine ranging from 50,000 pesos to 200,000 pesos shall be imposed on any person who is found guilty of committing any of the acts mentioned in Section 155, Section 168, and Section 169.1. Based on the foregoing discussion, the IPO Director of Legal Affairs had jurisdiction to decide the petitioner's administrative case against respondents, and IPO Director General had exclusive jurisdiction over the appeal of the judgment on the IPO Director of Legal Affairs. No. So here, we will continue discussing Bureau of Documentation, Information Technology. Okay, and transfer. Now, the Bureau has the following functions. First is to support and search the examination activities of the office through the following activities. They can maintain and upkeep classification systems, whether they be national or international, such as the International Patent Classification System. Provide advisory services for determination of search patterns. They can maintain search files and search rooms and reference libraries. They can adapt and package industrial property information. They can also establish networks for intermediaries or regional representatives. They can educate the public and build awareness on the intellectual property through the conduct of seminars and lectures and other similar activities. They can also establish working relations with research and development institutions as well as with local and international intellectual property professional groups and the like. So they can also perform state-of-the-art searches. Promote the use of patent information as an effective tool to facilitate the development of technology in the country. They can provide technical, advisory, and other services relating to the licensing and promotion of technology and carry out an efficient and effective program for technology transfer. They can also register technology transfer arrangements and settle disputes involving technology transfer payments. So how do you manage information services and EDP Bureau? The Bureau has the power to conduct automation planning, research and development testing of systems, contracts with firms, conducting purchase and maintenance of equipment design, and maintenance of systems, user consultation, and the like. So number 2, there's a need also to provide management information, support, and service to the office. Now that's Section 12. How about Administrative, Financial, and Human Resource Development Service Bureau? This bureau is composed of different service units of the office, namely the administrative service that provides services relative to procurement and allocation of supplies and equipment, transportation, messengerial work, cashiering, payment of salaries, and other offices obligation, office maintenance, proper safety and security, and other utility service, and comply with government regulatory requirements in areas of performance appraisal, compensation and benefits, employment records, and reports. Receives all applications filed with the office and collect fees therefore, and publishes patent applications and grants, trademark applications and registration of marks, industrial designs, utility models, geographic indication, and layout designs of integrated circuits registrations. So the Patent and Trademark Administration Services that shall perform the following functions. They can maintain registers of assignment, merging, licenses, and bibliographic on patents and trademarks. They can collect maintenance fees, issue certified copies of documents in its custody, and perform similar other activities. They can hold in custody all the applications filed with the office and all patent grants, certificate of registrations issued by the office, and the like. And the financial service that formulates and manages financial program to ensure availability and proper utilization of funds. Provide for further effective monitoring system of the financial operations of the office. And the Human Resource Development Service shall design and implement human resource development plans and programs for the personnel of the office, provide for the present and future manpower needs of the organization, and maintain high moral and favorable employee attitude towards the organization through the continuing design and implementation of employee development programs. Now, they also have enforcement and visitorial power. Under Republic Act 10372, added the following powers to the Director General. He or she can undertake enforcement functions supported by concerned agencies such as the PNP, the National Bureau of Investigation, the Bureau of Customs, the Optical Media Board, the local government units, and among others. They can conduct visits during reasonable hours to establishment and businesses engaging in activities violating intellectual property rights and provisions of this act based on report, information, or complaint received by the office and such other functions in furtherance of protecting intellectual property rights and objectives of this act. Pursuant to this amendment, the Director General issued Office Order Number 13170, Series of 2013, promulgating the rules and regulations in the exercise of enforcement functions and visitorial power of the Intellectual Property Office and creating thereby an Intellectual Property Rights Enforcement Office. For academic discussion purposes, the said office order is discussed below despite the author's reservation as to its validity. No. So we have here IPR Enforcement Office is headed by the Deputy General or an officer in charge of the IPR enforcement assisted by duly designated personnel of the Intellectual Property Office assigned law enforcement officers. In the exercise of its enforcement functions, particularly in the conduct of visits to business establishments, the IPR Enforcement Office shall be accompanied by the concerned enforcement agencies. If necessary, they may request from the said law enforcement agencies a detail of law enforcement officers in the IEO to ensure smooth implementation of its enforcement functions. Commencing enforcement action. When you enforce action refers to any action taken by the IEO relative to the complaint or report with the end of viewing, ensuring compliance with the provisions of intellectual property law. As amended, any right holder or authorized representative may file a verified complaint containing others the nature of IPR violation, complete details of the place or establishment to be subjected for visit, and certification against non-forum shopping. The rule to limit IPO's enforcement power to manufacturing, production, importation, exportation, distribution, trading, and offering for sale, including other preparatory steps necessary to carry out the sale of counterfeit and pirated goods. Actions on the complaint. Complaints for enforcement action shall be referred to the IPR enforcement officer, who shall evaluate and validate these allegations within 30 days from the referral of this case, and upon due evaluation thereof and finding evidence of violation of IPR, recommend to the Deputy of Director General or an officer in charge for IPR enforcement any of the following enforcement actions. They can issue a notice warning to the respondents to observe compliance with the intellectual property law, issuance of visitorial power of subjected premises, issuance of compliance against the respondents, immediate filing of administrative complaint before the local government unit and other government agencies, referral of case to a law enforcement agency for case build-up, recommendation of application for search warrant, dismissal of the complaint, referral of the case to other government agencies for filing charges of violation of other laws, and such other actions necessary to ensure compliance of the Intellectual Property Code. So what is the responsibility of the complainant? The reports and information received by the IEO shall be duly recorded and validated by the designated enforcement officer. Upon the recommendation of the enforcement officer, the concerned right holder or authorized representative shall be required to coordinate, to pursue and maintain enforcement actions on the report. Failure of the right holder or authorized representative to initiate a necessary complaint within 1 month from the notice shall cause the dismissal of the report. 1 month lang ang tagal, no? And the due notice thereof shall be related to the informant for the apparent lack of interest in the right of holder to pursue complaint. How about the visitorial powers? After due evaluation, the Director General of an officer in charge may issue a visitorial power on the subject business establishment for the purpose of ensuring compliance with the provisions of the Intellectual Property Code as amended. The visitorial order shall in no case be valid for 10 days from the issuance thereof. So in the conduct of the visit, the subject business establishment, the authorized personnel thereof must act with courtesy to the owner's employees or representatives of business establishment. Upon arrival of the premises, the authorized personnel together with the product specialist or right holder have seen in plain view the presence of counterfeit or pirated goods. They have the reasonable ground to believe that the business establishment is engaged in manufacturing, production, importation, exportation, trading, and offering sale, including other preparatory steps necessary to carry out the said shall be forthwith relayed to the owners or employees of the business establishment. Any objection or justification by the owners, employees, or representative of the business establishment shall be noted by the authorized personnel. So within 10 days from the conduct of visit, a post-operation report together with the recommendation thereof must be submitted to the Deputy Director General or an officer in charge of the IPR enforcement for appropriate administrative action. So here, the Deputy Director General or an officer in charge of the IPR enforcement may issue a compliance order to the concerned business establishment before the appropriate administrative action is initiated. So any person or business entity served with a compliance order relative to the complaint violation IPR provisions of the IP code may avail of the compliance period of not more than 6 days to avoid being subjected to an administrative action. So we are now in the summary part. We have to summarize everything we have read. These are the laws that you have to remember. The IPO replaced the Bureau of Patents, Trademarks, and Technology Transfer. So we have Intellectual Property Office already. The Intellectual Property Office is headed by the Director General, who is assisted by 2 deputies Director General. The IPO is divided into 7 bureaus. Each of them is headed by a director and assisted by an assistant director. The Director General, deputies Director General, directors, and assistant directors of the IPO are appointed by the President, and the other officers of the employees of the office are appointed by the Secretary of the Department of Trade and Industry, conformably with under the Civil Service Law. The Director General has been divested of an original jurisdiction to resolve disputes relating to terms of license involving author's right to public performance or other communication of their work. This is now the jurisdiction of the Director of Copyright and other related rights. The Director General has exclusive appellate jurisdiction over all decisions rendered by the Director of Legal Affairs and the Director of Patents, Director of Trademarks. The decision of the Director General in his exercise of appellate jurisdiction may be brought to the Court of Appeals or the Secretary of Trade and Industry, depending on where the case is emanated. The Supreme Court sustained the power of the Bureau of Legal Affairs to exercise jurisdiction over administrative complaints. Again, you look at In and Out Burger case wherein they have concurrent jurisdiction over administrative complaints involving intellectual property. And the law recognizes the current jurisdiction of civil courts and the IP over unfair competition cases.